Why were you going to lie to me? Yeah, okay, so hold on, before you start, hold on. The one thing about me is I hate when people lie to me.
It does.
You know what? You know what? You need to stop. Calls the case, People versus Patrick Lay.
And Assistant Public Defender Chinazi Carrie ruling on behalf of Mr. Patrick Lake. Are in negotiations with the people and yet to reach a resolution.
Pardon?
We are asking for an adjournment, Your Honor, for purposes of further negotiation.
Oh. So, what do I do about his violation?
Oh. Give me a second. I apologize, Your Honor, I did not.
There's emotion of tracking. It was granted.
What city are you living in?
Ypsilanti.
Yesterday?
Yeah, did you go yesterday, right?
Yes, I did. I'm sorry.
Did you text?
I did.
What was the result?
Positive.
For?
For what?
Amphetamine, Your Honor, he says. The court mind passing this, I did not know about.
I do.
Yeah, let me.
I do mind passing it.
No, she-
Did you test? Hold it. No, I'm not passing it.
Okay.
Did you go over and test?
Yes, I did. And she stated that she made a motion to the courts of retracting her violation because that she made the motion towards not retracting, but like recalling the violation request, and they granted her it. She said, Ms. Dozier.
They did what?
They granted she requested for a violation. Okay.
So, Your Honor, it looks like Ms. Dozier sent an email.
Okay.
Indicating that there was a violation for his failure to contact community corrections. And then she sent another email on Wednesday indicating, good morning, I sent a violation report for Patrick Lay closing supervision interest due to failure to report to community corrections. He did make contact this morning after his mom made him aware that I called. He scheduled an intake at 1:30. So this is where he now states that he did go and test at the 1:30 time, or he went to do his intake at 1:30. You said.
And he tested.
Yeah.
And that's what I want to get to.
Yeah.
He tested. And
according
he was
to his
positive.
statements today, Your Honor, it indicates that he was positive for amphetamines.
And do you have medication that you take?
I do not, Your Honor.
Okay, that's going to be a problem.
And this message with Ms. Dozier, she confirmed that his test indicated that he's positive for amphetamine. So now I asked that the follow-up question is, what for that? And I got the little bubbles that she's typing.
So, Your Honor, Mr. Lay indicates that he did have a conversation with Ms. Dozier after the positive test. Ms. Dozier is hopefully going to be able to refer him to CCOP, is what he's saying. He says that they discussed treatment options or things that would kind of help him, I think, based on the underlying offense. The 1298 is a possession charge. I think that we should absolutely focus or try and see how we can get Mr. Lay connected with substance abuse services.
When's the last time you used?
The day of my arrest, October 30th 10/29, sorry, 10/29/24.
On the 24th?
No, on the,
10/29/24, Your Honor, which is the date of his.
So,
for the
and then you were told on the 30th, you're saying you used before then?
yeah, I used that day.
The 29th?
Yeah.
And not, okay, young man.
What?
And not since then?
No, I have not since then. I mean, that's okay. I did. Okay, I took it.
Yeah, okay, so hold on, before you start, hold on.
Sir.
Hold on. The one thing about me is I hate when people lie to me.
Okay.
I really do.
Okay. All right.
So, okay, so hold on. So make sure what you're gonna tell me is the truth, Mr. Allen.
So the last time I used Adderall was about 3 days ago.
Yeah.
Yeah, that's the truth, Your Honor.
So why were you going to lie to me that it was the day of your arrest? Why were you going to lie to me that it was the day of your arrest? I can exactly tell you why you
I'm
didn't
scared.
tell me that.
Your Honor.
Yeah, you were scared, but why were you going to try to give me the day of your arrest?
I guess
Because that would have been before you were told by the court not to use.
okay. Well, yes, Your Honor. Your Honor. Yeah. And yes, also, when I did get out of jail or holding, I guess I didn't get sent home with the paperwork saying that I had a test 24 hours after my thing, after I got released, which I didn't have with all my paperwork.
So I realize we're past that now.
Okay. Okay. Okay.
I understand maybe why you didn't show up. What I don't understand is why you were using. And then I don't even further understand after using, getting and testing then positive. And then when I asked you a question regarding it, you lied to me.
Okay. I guess I was scared, Your Honor, for the sake of, well, one, I had to show up because it was better to show up and I guess maybe fail and just still be here. Because I know a no-show is also testing positive as well, the same thing. But I wanted to insert myself in I want to make myself better. And I want help because I need help, Your Honor. The lying part, I'm shameful for. I'm just, like I said, I'm scared. So I do want help. Why I went to Affirmative Corrections when I was told I'm into zero.
Are you sure it was 3 days ago? Because as I'm listening to you, I think you took it well after that 3 days.
No, sir, I'm just scared. I really am. I'm honest, sir. Like for 3 days, that's when I last took Adderall. I mean, okay. I didn't take it. I haven't taken any today. I mean, like 2 or 3 days ago would be like the minimum.
So it was 2 or 3 days.
I mean, I haven't. Okay, so what day?
You want to know why?
I'm sorry. It wouldn't be any less than 2 days ago.
Today is the 7th.
Okay, so Tuesday. I guess it would have been Tuesday. It would have been Tuesday. I didn't look at the dates.
So that's 2 days ago, not 3.
I'm sorry. I didn't really look at the dates. I'm sorry.
Pardon?
I didn't look at the dates and I didn't know like exactly how to reference. I'm sorry. That is the truthful answer, Your Honor. I'm just nervous.
So that's the truth now,
It is the truth.
after 2 attempts.
No, the second time was not like meant to be a lie. It's just I didn't really calculate the day exactly. I'm sorry, sure. That is the truth. That is the truth.
It's okay.
There's no other like answer that I can give you. That's. I'm sorry. I'm just very nervous.
Me too.
Your Honor, if I may.
Please.
Yes. Your Honor, I obviously I understand exactly how, what position the court is in right now. No, well, as
I'm in the
your
same
options.
position as when I walked out. He's in a worse one.
This is
But
absolutely.
go ahead, I'm listening.
Your Honor, Mr. Lay is here today. When he was told to come to community corrections, he came, knowing that it was very likely that he would test positive, but was willing to deal with the outcomes because he understands that it's important that he appears to court and he makes sure that he abides by the requirement to come to court. He has an addiction based on our underlying crime and these new bond violations. I'm asking the court to consider at least getting him into the CCOP program as soon as possible. Any other outpatient treatment program available to him. He's not a flight risk. He's here. He's here. He came to community corrections. He's come to court. I know that the people will say that one of his charges are an RNO, which is problematic in and of itself. However,
The other one's in the possession of the drugs
and then the other, that's
that he
correct.
was using after being told not to. Go ahead, I didn't mean to interrupt. I was
That's
just
okay,
trying
Your
to
Honor.
make it straight.
We're just asking for the court's consideration. I know traditionally in this type of situation, the court would consider a remand. We're asking that the court reconsider that and at least allow or order my client to get into some type of treatment immediately.
Well, while you can sit up there and arrange that, that's fine. But I'm not going to have somebody not only use after being told not to, then lie to me about you.
I didn't mean to like, okay, I'm sorry, sir. I do need help with it. I'm genuinely seeking it. That's why I came to community corrections regardless of my fear or not.
So where are you seeking help?
I'm seeking help for resources of like people that like, or I guess you can't change yourself until you change like how you go about like being happy. So I'm just seeking new opportunities, whether it be via work or new outlets of, like people that are positive in my life, that are stronger based on their efforts they made to become sober and become happy in life again, fulfilled. I'm just seeking help as far as just being around people that can guide me and support me through becoming sober.
So have you found any?
What? I'm not like genuinely, no. I'm not saying I don't really have a lot of friends anymore or support. My family is a good support. I'm really close to my family still. I'm in good terms with them.
Have you asked them to find you help?
I've asked them about moving back in with them. They live in West Springfield.
Have you asked about finding help?
They said they would be 100% supportive of helping.
Pardon?
Yes, I've talked to them recently about that within the last like 2 weeks. And they said they would be supportive of finding.
Have you called any place to try to get into any treatment, young man?
I just got like links and numbers from Mr. Ozier yesterday.
So prior to you going to community corrections, you hadn't done anything?
I guess not, Your Honor.
Yeah.
But going to community corrections was my first step into like realizing that like stuff needs to change my life. And it really does.
You know what?
Does
You know what? You need to stop
I know.
because you haven't done anything.
I know.
And that would have been the answer to my question. I don't know why you're trying to make everything when I ask you a question something more than what it is.
I'm sorry.
You haven't done anything. You continued using. That's where you are. So until such time as you decide to be honest about it, nothing's going to work anyway.
I think it might. I know it will. I know it will because I can't risk myself not benefit, like myself growing. Like I'm not gonna risk that. Like I would not like to risk that. I think I'm stronger than I am. Truly, sir. I know I am.
I'll adjourn probable cause to next week, November 14th, 2024 at 9 a.m. At this time, defendant's bond is revoked. You're remanded.
Thank you, Your Honor.
Yes. So I don't have a week.
Good afternoon, Judge. Jackie Mossbohr, and on behalf of Mr. Heenan, who is present to my right.
And John Shea, Your Honor, is
All right. Okay, Mr. Heenan, and the record should reflect, just to briefly set it out, that while we were waiting for the courtroom change, I had a bench conference with counsel, and given those discussions, Mr. Heenan was, prior to calling his case, sent over to Community Corrections to obtain a scram tether and also to take a full panel drug test. Went over, did that, came back a 0.10 on a PBT, could not have the scram tether put on because of that. And also came back in terms of his drug testing with a possible dilution in terms of the creatinine level. Came back positive for benzos, and came back for positives on benzos. Mr. Heenan, let me ask you this. You blew a 1-0. When did you stop drinking? When's the last time you had a drink?
So about 4, I woke up and my hands were shaking. So I drank some high noon. And then at
How much high noon did you have?
just enough till my hands stopped shaking.
Okay, what's that? Tell me what that means.
Like for me, it's like 4 to 6. And then at 7 this morning, when the liquor stores open, I had a DoorDash delivery of more high noon. And I drank again until my head stopped shaking.
And how much did you have that time?
Your Honor, honestly, I just kept drinking until my hands stopped shaking. It was a 4-pack.
Okay, it was a 4-pack?
High noon comes in 4-pack.
Right. And so did you drink them all?
Oh, yeah.
Okay. And how long did that take you?
I chugged.
Okay, so that DoorDash delivery at 7, that was the last you had?
Yes, and my hands were shaking, so I've got a bunch of empties, and this is how desperate I was. I would pick up all the empties on my table and see if there were sips. And there was one that was like that full, and I chugged that as well.
Do you think you're in trouble? I mean, just not with the court. I'm not talking about with the court, but just with you and your sobriety.
I do. I have 16 years of sobriety. So I know I can do it. I'm just having a hard time right now with this divorce and losing the kids. And just life is hard right now. I had to resign my job I loved. It's just been rough.
Okay, so right now you're also not working.
I had to resign to go to treatment.
I'm just going to let you know that you're going to be staying at the Washington County Jail, temporarily revoke your bond. Okay? And I'm not doing that necessarily as a punishment, but I have no way to release you and keep the community nor you safe. At this time, the bond is revoked. Case People versus Peter Heenan.
Prosecuting attorney, those 4.5 people.
Good morning, Your Honor. Jackie Moss on behalf of Mr. Heenan, who is approaching.
All right. How are you doing, Mr. Heenan?
Doing okay, Your Honor.
Okay. Where are we on this? Did we get any update on Bear River?
Your Honor, in regards to Bear River, yes, the update is Bear River can have Mr. Heenan admitted within 24 to 48 hours. However, they would require the referral from CMH. That was not able to take place yesterday because CMH said they required an order from Your Honor before.
For CMH to evaluate him.
Yes.
Here's what I'm going to do. and you're not gonna like it, Mr. Heenan, but I'm making the call. You're not going anywhere. I'll sign the order. You'll get assessed on Friday. And we're gonna get you out to Bear River and start this process. Mr. Heenan, how'd you get here yesterday?
I drove.
Yeah. And I'm letting you know that that factors into my decision because, Mr. Heenan, by the time we got you over to community corrections, and you had already been here a while. It's that behavior that, and again, I'm not saying that you're a bad person, but your inability to make a proper judgment on that, that leads me to the conclusion that I have to keep you right where you are, get an order, get CMAs to talk to you, and get you into treatment. Court does call the case, People versus Peter Heenan. Bless you, whoever that was.
Jessica Blanche.
And may it please this honorable court, Michael Nichols on behalf with Mr. Heenan. Thanks.
Okay.
Yeah, quite a few things going on.
Yes. Mr. Heenan, how are you, sir? State your name. All right. Okay, where are we now on this?
Your Honor, I picked him up at U of M, 2:15
Today?
today.
Okay.
I took him to his apartment so he could pack a bag. Had my eyes on him the whole time.
Yes, sir.
And you know what? You don't know me, Your Honor, and neither does Ms. Blanche. My plan today was to be at Comerica Park watching Terry's Google pitch. And I thought about it. I said, how many times do you get to see that? But how many times do you get to try to save a life?
That's it.
And that's what we're doing. Right?
Okay, so here's what I want. I'm not gonna lock you up, right? I don't want to do it. I'm not gonna. You're to get enrolled, get yourself in a bed, and I want you there by tomorrow. Got it? So one thing that you learn about me, Mr. Heenan, and anybody will tell you this, if I give you my word, I'm going to walk that walk with you, do what I can. Some things I can't do, but if I say I'm going to do that, I'm going to do it. If nothing else, I'm a man of my word. Because every day, Mr. Heenan, I wake up and I just hope that I get to see a miracle. Sometimes you don't even know a miracle when you see it. But what you've been on for the past couple weeks, the very fact that you walked through those doors, that's my miracle for today. I'll get it done. All right. And we'll look for the updates. Okay. Your people of the state of Michigan versus Peter Heenan. First of all, thank you, counsel. We had sent an email because I had actually issued the bench warrant based upon the previous history as well as. Have you received a copy of the report, sir?
Yes, I have, Your Honor.
All right.
So, Your Honor is obviously aware of the alleged bond violation. We would, first thing, there is a preliminary examination for the underlying charge, I believe, scheduled for the 31st. With that existing court date in mind, Your Honor, what we would like to do today is request a hearing on the bond violation, and I'd ask that Mr. Heenan's bond be continued.
Is there anything from the people? Go.
I think his bond needs to be revoked at this time. I think we have had multiple violations. We've tried a softer touch and it's not been successful. I'm concerned at this point.
If I may, Your Honor, I would like to apprise the court of what Mr. Heenan has informed me of. He has enrolled in a sober living facility, a sober living program. As a part of that program, there is a therapeutic assistant that would come into Mr. Heenan's home and be with him, monitoring him 24/7. Mr. Heenan enrolled in those services yesterday. He could give you the details, but I would say I know he spent a great expense to enroll in this program, Your Honor.
I have to say that I'm still concerned about that. I think at this point, one of the things that I'm seeing is that Mr. Heenan doesn't have much of a support system. I remember that we have talked previously about potentially doing an inpatient program where he would be inpatient somewhere where other people who have addictions are also inpatient, building a network of support there, then moving to transitional housing outside of his home where he would have an additional support network there, and then continuing with the larger support network, gradually reintegrating back. At this point, I don't see that he would have any training wheels or safeguards, because what you have is someone coming into his space. That's not expanding a support network. That is equipping him for a finite amount of time until this assistant is no longer going to be able to watch over him for 24 hours, and then they cut and run. And he still has not established any type of larger support network to facilitate long-term sobriety. I don't think that that is sufficient. I understand that it's a great expense, but it doesn't to me seem to be anything more than a Band-Aid for a situation that really needs to be addressed at the root cause, which is the addiction with the lack of support system.
When do we want to do this hearing? Want to try to shoot for the 31st. I'll set it for a hearing on his bond violations, as well as our probable cause conference is set for that date in any event. But now everything will be set, council, at 3 p.m. for the hearing on that day. Okay, Mr. Heenan, I made you a promise, right? Sometimes, because I don't like sending people to jail, particularly, I don't like locking people up, but I'm going to keep my word, because here's the thing. If I let you walk out of here, and there is going to come a point where I don't know that we get you back. That's the reality. So at this time, we'll see everybody on the 31st, but at this time, defendant's bond is revoked. We'll have the hearing on the 31st.
Okay, thank you. Your Honor.
No bond. Thank you.
Morgan Poisson for the people.
Jackie Moss Ford on behalf of Mr. Heenan, present seat to my right.
All right. What are we doing on this today?
Your Honor, I'm going to be requesting an adjournment. I did make all efforts in order to have my necessary witnesses present. However, the community corrections agent, he was out of office before I even reached out to him, and he's not going to be back until after today. I did get indication from his staff saying he would be available for November 7th at 3 p.m. Additionally, Mr. Hayes, who is the Scram expert, was not available. He had an exact conflict at like 2:50 today for another hearing, so he was unavailable to testify today as well. He is also available for November 7th at 3 p.m.
Okay.
They have no issue appearing then. Mr. Hayes did indicate it would be best for him if he could testify over Zoom, which I know you've accommodated in the past. If not, he would just need to know, but I would be requesting that we turn this out 1 week.
All right. Any response?
Yes, thank you, Your Honor. The prosecutor's office did reach out and relay to us everything that was just stated. That being said, today is the daytime that was set for the bond violation hearing, and because Mr. Heenan is in custody, I would object to an adjournment at this point.
All right. Well, there's a couple of ways that I can do this, because it seems to me,
I have a feeling I know what you're looking at.
did you get a copy of the letter?
The letter, yes, I did.
October 29th?
Yes.
Everybody else got it but me. Okay, good. All right. As long as everybody got it, we're okay. The thing is, I mean, the reality is I could let Mr. Heenan out. But if I let Mr. Heenan out under those same terms pending a hearing, it could be that he goes right back in after the hearing.
May I, Your Honor?
Yes, go ahead.
May I propose adding, if Your Honor were to reinstate bond, perhaps add the condition of spoken with Mr. Heenan. He's not opposed to Vivitrol is a medication that we spoke about. I know that is a injectable medication taken monthly that is supposed to curb the help with alcohol addiction and abuse is another medication. I would ask Your Honor to consider, if Your Honor is going to reinstate bond, perhaps adding some additional conditions that may alleviate the court's concern about Mr. Heenan abstaining from alcohol.
I wouldn't have a problem with that necessarily. I mean, the antabuse I'm going to have a problem with because what that is going to require is that Mr. Heenan take it. And regrettably, not because he wouldn't want to, but I can't rely upon Mr. Heenan doing it.
So that's why I led with the injection, Your Honor.
With the injection, how soon could that be set up for him? Because just given the history of this case, I can't have any gaps. So I couldn't let him out, say it's going to be 3 days before he would see the doctor and get the injection.
Yep.
Has that even been broached to set up for him? Or do we know any of that?
No, Your Honor, it has not. I could start making calls first thing tomorrow morning and start working on getting that set up if the court was willing to entertain that.
Do the people have a position on that?
I don't think that letting him out at this time is appropriate because he's just going to go home. And I understand he had a in-home sober living coach set up. I still am circling back to the conversation that we had where we had this whole plan. It was going to go to inpatient and then do some kind of transitional and then work on reintegrating to living independently, setting up a support network. I think that this is, to me, what this sounds like is yet another temporary solution or temporary treatment of a symptom without managing the larger issue, without managing the lack of a support network and the other issues that he has going on leading to and coexisting with the addiction. I don't feel comfortable setting him up in this way. I told counsel, I think that if he had a spot in transitional or if he had a spot in an inpatient that he didn't handpick leading towards some type of transitional, I would feel a lot more comfortable proceeding in that route. But I don't see how this is actually doing anything to work towards a long-term solution here.
I'm not, and quite frankly, I'm not sure that is really what we're looking at in terms of a long-term solution. It might be part of one, but I'm looking at trying to balance the fact that the hearing was set for today. He's in custody. I do understand the difficulties in terms of making sure that everybody can be here, but doing something in the interim between now and next week to try to resolve it. I would not be, so that I'm again clear, there would not be a gap where I would be letting him out, say today, to set up an appointment that may take place Friday or whenever, next week. I'm just not doing that, given the history of the case. I think I would allow counsel to set that up, but I would have to know what doctor would be administering it, how often it's going to be administered. I mean, I would have to know details of what's going to happen and try to limit, and I'll just put it this way. I mean, Mr. Heenan, with alcohol, you're like a hamster in a cage. Just you spend your time trying to figure out how to get out. And so we just try to be limiting as much we can as humanly possible his ability to try to do anything along those lines. So what I'm going to do is this, and certainly counsel, I will entertain it when I see it.
Sure.
In terms of any type of release, but I'm going to grant the adjournment to the 7th at 3:00. At this time, I'm sorry, that's 11:07. And I'll set the probable cause at that same time, so. At this time, what I would do, though, is continue his bond as is, subject to counsel getting that information to me to see if there's something else we can do in terms of a release structure for Mr. Heenan.
Okay, and a question about that, Your Honor. I'll absolutely get on the making the phone calls first thing tomorrow morning regarding the doctor and the medical side of things. What is Your Honor's position in terms of would the condition also include the transitional housing or something else that I should look into as well?
Yes, I think counsel's right. What we were doing was he was to go into the program, transition into transitional housing, develop that network.
That was my recollection as well.
And then continue on. He didn't do that. He gave me his reasons, and they're understandable, I guess, but it was somebody that wasn't willing to put forth the effort to make sure that happened. And then that's when we end up with this, right?
Yep.
So if counsel would look into that also, I think that would long range be helpful in terms of trying to address the issue. All right.
Yep, understood. Yeah, we'll do. I'll look into both matters and be in touch with your office as soon as I have information.
All right. Mr. Heenan, how are you doing?
Thank you, man.
All right.
For asking.
Are you?
Much better.
All right. Okay, go ahead, counsel. Sure.
Thank you, Your Honor. Today was the date and time scheduled for a violation of bond hearing. I've had communications with the prosecutor's office and conversation with Mr. Heenan. Mr. Heenan is willing to make an admission regarding that bond violation, Your Honor.
Okay. And so, Mr. Heenan, you admit to the violation?
Yes, Your Honor.
And with that also, Your Honor, there was a conversation with the prosecutor regarding the reinstatement of Mr. Heenan's bond. It's my understanding that the prosecutor would not object to Mr. Heenan's bond being reinstated, along with the additional conditions that were previously stated on the record.
That is correct, Your Honor, with the understanding that Mr. Heenan is to be released to treatment.
Yes. All right. What I will indicate is that the defendant's bond is reinstated with specific release to treatment. Mr. Heenan, that's what you want to do, right?
Yes, Your Honor. Thank you.
All right. So I'm going to give it another shot here, Peter. All right. So
I apologize.
go ahead.
I am making the request formally on the record, though, that if for any reason that Mr. Heenan is no longer in treatment, a condition of his bond be that he let the court know within 24 hours that he is no longer in treatment.
Okay. I am signing a community corrections order. So this is the way we've laid it out here. And what will end up happening is that I'm going to release you, but you're going to be held because you have to have a tether on you, or not only to be released to your sister. You understand that, for transport to Sanford. Understand that?
Yes, Your Honor.
All right. So specifically what's going to happen is they're going to come over at some point tomorrow, put the scram tether on you. All right. Then they will, and then Saturday, you'll still be incarcerated. Saturday, and I put down here at 8:00, you will be picked up by your sister. You are then to be transported there across state. There will be no stops. No matter how much you ask her, don't even ask her. I've myself spoken with her, and that is all that, and I know she'll follow my direction. That is all that she's to do.
Yes, Your
Is
Honor.
get you from that spot across state. Understand?
I understand.
So the order specifically reads that the tether will be placed on Friday, November 8, 2024. Defendant will be released to Sanford Behavioral Health on October 9th, 2024. Defendant will be picked up on Saturday, 11/9/2024 at 8 a.m. by Lydia Marshall. And then we place her date of birth in there, and she will show ID at the Washtenaw County Jail. Ms. Marshall will transport the defendant directly to Sanford Behavioral, and then we give that address of that location, and she will transport you on that date. You have an admissions time of around 11:00. So we have certainly, I think, given enough time. It further indicates that the defendant is required to notify his defense counsel and the court upon his discharge for any reason from Sanford Behavioral Health. All right. And I will add the one in there, and that's to be, I'm not going to give 24 hours. If he's discharged, he's to notify within 12 hours. I'm going to put, all right?
Your Honor, if I may, I just want to clarify. I believe I heard Your Honor, as you were reading, read the date of October. I just want to make sure it's written in.
Did I say October 8th?
That's what I heard.
Yeah, it's October. It's November.
Okay.
Sometimes I get those months mixed up. Sometimes I'm having Thanksgiving at Halloween. It's a whole thing.
Okay.
It's a problem for me. All right. You understand everything?
I do, Your Honor. Thank you.
All right. So we're going to do it that way. And then we will proceed from there. What I will do is I will put the sentencing on the violation
Your Honor,
as well as, yes.
at risk of pushing the court's patience today, because,
You've already done that. I'm
I
way
know.
past that. So go ahead.
but, pushing it further, it's my understanding that the length of time Mr. Heenan is at Sanford is anywhere between 2 and 4 weeks. Because of that, I would be making the bold request of going out 1 week, just so that Mr. Heenan can appear via Zoom and we check in to see if we want to, when we would potentially like to set for preliminary exam, if we would want to do that while he's still.
So you think the 14th? I just, sure, we can do that. I just want to make sure, because usually there's that period in time upon admission that they won't. I was going to set this for the 21st, but the 14th, if you want me to set it for the 14th, I will. That's not pushing anything.
I have no objection.
All right. So the sentencing on the violation, as well as the probable cause conference in this case, then will be adjourned to November 14th, 2024. I'll set it at 9, but we'll set that. Okay. Anything else from either side?
And Mr. Heenan is allowed to appear via Zoom from.
Yes, he will be allowed to appear via Zoom. If there's a problem, and counsel, you may have to contact the facility. If there's a problem with him appearing via Zoom, just let the court know and we'll figure something out. Or if it's sometimes that they won't let it happen in the first period in time after his admission. So if we're in that window let us know and we'll figure it out.
Understood. I will keep the court apprised.
All right? Mr. Heenan, good luck.
Thank you, Your Honor.
All right? Remember what I said the last time? And you finally acknowledged that sometimes you take the easy way because it's easy, right? So let's give a shot here of trying to do it maybe the hard way. All right? And it's going to be a struggle. It's going to be whatever. But just try to just bear down and just get yourself past it and just take the hard path. Sometimes, ultimately, that will be the easy path.
Thank you, Your Honor.
Right? All right. Good luck to you.
Thank you very much.
Thank you, Judge.
Thank you. Yeah, we can put it in whatever. At what time?
5:00. I did not respond. We can.
I just had it.
Throughout these hearings, one message remained consistent. Accountability begins with honesty. The court acknowledged the challenges the defendant was facing, but also made it clear that trust must be earned through truthful answers and consistent actions. Rather than relying on punishment alone, the judge carefully balanced community safety with opportunities for treatment, repeatedly emphasizing that lasting progress requires commitment, structure, and personal responsibility. As the case evolved, the court adjusted its decisions based on the defendant's choices, ultimately allowing another opportunity through a closely supervised treatment plan with clear conditions. This case serves as a reminder that the justice system often weighs compassion alongside accountability, and that every second chance carries the expectation of genuine effort. In the end, the courtroom's goal wasn't simply to decide what happened next. It was to encourage meaningful change while protecting the public and upholding the integrity of the legal process.